Hello everyone, my name is Nursharina Binti Abdullah. My metric number is BD33103. So today I will explain the first issue, which is whether Minho can legally keep the 10,000 ringgit he received using a check that was altered by one bit. So under section 16 of the Bills of Exchange Act 1949, a check that has been materially changed without the drawer's consent becomes void. Meanwhile, section 25 clearly states that if a check is crossed with the word not negotiable, then the person can get a better title than the person who passed it. So, in our case, Wonbit stole the check and used chemical ink to change the payer's name without authorizations. Minho then received this check in exchange for a television. Even if Minho was unaware of the fraud, the law does not allow him to keep the 10,000 ringgit. He has no better title than Wonbit, who was not authorized to use the check at all. This principle is supported in the case of London Joint Stock Bank Limited versus Macmillan and Arthur, where the court held that a party involved in a fraudulent check transaction cannot claim legal ownership. So, legally Minho must refund the money, and Hyun Bin has the right to get it back. Next, we look at the second issue, which is whether Rupa Bank or Juta Bank is responsible for processing the altered check. Under Section 61 of the Bills of Exchange Act, a check is a bill of exchange payable on demand, and Sections 85(1) provides that a collecting bank is only protected from liability if it acts in good faith and without negligence. Although Rupa Bank is issued the original check, the fraud took place after it was issued, so they are unlikely to be held liable unless they failed in initial processing or security checks. However, Juta Bank, which collected the check on Minho's behalf, could be liable if it failed to check the check carefully. Since the check was chemically altered, if the bank did not detect the change or make proper inquiries, this could amount to negligence. So, this point is clearly explained in Ledbrook and Co. versus Todd, where a collecting bank that acts negligently cannot rely on legal protections. Similarly, in United Asian Bank versus Tai Sun Heng, the court emphasized that banks must be prudent and careful in handling checks. So, in conclusions, while Minho must return the funds, Juta Bank's liability depends on whether it acts responsibly and within its duty of care. So, to conclude these two issues, Minho is not entitled to 10,000 ringgit because the check was dishonestly altered. Rupa Bank may not be directly liable, but Juta Bank can be held accountable if it failed to follow proper banking procedures. This issue highlights the importance of applying the Bills of Exchange Act 1949 and ensuring all banks follow strict protocols to prevent fraud.
My name is Laila Natasha Binti Zulfazly, and my matrix number is BB22110755. And next, I will continue explaining the following issue from scenario 2. Before I begin, let's quickly recap the scenario. In this case, Wonbin, a restaurant manager, stole a check and completed by forging Hyunbin's signature for the amount of 15,000 ringgit. The check was then presented to Rupa Bank. Although the bank officer, Mr. Lazi, found the signature suspicious, he still cashed the check without making any attempt to verify it. Additionally, the check was cross-account payee, yet it was still paid out in cash. So, the issue that was highlighted in this scenario is whether Rupa Bank is legally liable for paying a check that was forged, specifically signed by someone who wasn't authorized, which in this case is Wonbin. According to Section 24 of the Bills of Exchange Act 1949, any check with a forged signature is considered void. It has no legal effect. This means the bank is not allowed to treat it as valid or use it to debit the customer's account. In the case of London Joint Stock Bank versus Macmillan, the court clearly stated that if a bank pays out on a forged check, it is acting without the customer authority, and this makes the bank liable. This was also supported in the Malaysian case of United Asian Bank versus Tai Sun Heng, where the bank had to refund the customer, and under the case of Syarikat Islamiyah versus Bank Bumiputra, where the court confirmed that a bank has no right to debit an account without a valid mandate. In scenario 2, Rupa Bank did not have any form of approval from Hyun Bin to honor the check, yet they went ahead and paid it out in cash. Because the check was forged, it was legally inoperative and the bank had no authority to act on it. And even if the bank acted in good faith, the law still considered it strictly liable because there was no valid instruction from the customer. So, in conclusion, Rupa Bank is liable not just for being negligent, but for acting without any legal mandate. This means the bank has a legal obligation to reimburse the full 15,000 ringgit to Hyun Bin. And now let's moving on to the next issue. This issue focuses on whether Rupa Bank breached its duty of care by failing to properly check the check before making the payment. The signature was already suspicious. Even the bank officer, Mr. Lazi, said so. But despite that, he still authorized the payment without making any attempt to verify it. Under the common law, banks are expected to act with reasonable care, especially when handling high-value checks. In the case of Tai Hing Cotton Mill versus Liu Chonghing Bank, the court ruled that it is the bank's responsibility, not the customer, to detect forgeries and act accordingly. And in the Malaysian cases, the Malewar Apex versus Malayan Banking, the court said that if a bank officer has internal doubts, they are required to investigate. Failing to do so is considered negligence. In scenario 2, Rupa Bank had every reason to be cautious. Mr. Lazi noticed something was wrong, but did nothing. He didn't compare the check with Hyun Bin's specimen signature, didn't call the customer, and didn't hold the transaction for verification. This is a clear failure of duty. Banks are trusted to protect their customers from fraud, and in this case, Rupa Bank failed to do so. So the conclusion is clear. Rupa Bank breached its duty of care by ignoring the suspicious signature. As a result, the bank is not only liable for paying a fraud check, but also for its negligent actions, which allow the fraud to happen in the first place.
Assalamualaikum, my name is Aliyah. Now I will continue to present the scenario 3. The first legal issue is whether Roberto can sue Rupa Bank for conversion. This arises from the bank collecting a check that was stolen and outed by Robert. Conversion refers to the wrongful handling of someone else's property in a way that denies their ownership rights. For the rule, according to Section 24 of the Bills of Exchange Act, a forged or unauthorized signature makes a check completely void. Also, Section 64(1) BA states that a material alteration without the consent of all parties also renders a check void. Section 85, however, protects a collecting bank from liability if it collects the check in a good faith and without negligence. Case law, such as Rubber Industry Replanting Board against Hong Kong and Shanghai Banking Corp, and Asamaju Enterprises against Malayan Banking Berhad confirms that banks can be liable for the conversion if they collect checks for customers who have no valid title, especially if identity checks are not done. Next, applying these rules to the scenario, Robert stole a check meant for Roberto and outed it by removing the letter O, changing the payee's name. This constitutes both forgery under Section 24 and material alteration under Section 64(1) BA. Since Roberto never gave permission for this, the check is void. Rupa Bank collected this check for Robert, who had no rightful title to it. Like in the rubber industry and Asamaju cases, the bank held the property, the check, belonging to someone else without proper checks. This fits the definition of conversion unless the bank can prove it acted without negligence, which is addressed in issue 2. Therefore, Roberto can sue Rupa Bank for conversion. the bank wrongfully handled his check by collecting it for someone who had no right to it. Liability now depends on whether the bank was negligent, which we will examine next. Now I will move on to the next issue. The second issue is whether Rupa Bank was negligent in processing the stolen and altered check. This is important because Section 85 BEA only protects the bank if it acted in a good faith and without negligence. For the rule, according to Section 85 BEA, a collecting banker will not be liable if the check is collected in good faith and without negligence. In rubber industry against HSBC, the bank was found negligent for not verifying the identity of a customer who deposited a stolen check. Similarly, in Asamaju Enterprises, the bank was liable for failing to conduct proper checks. Also in Lumsden against London Trustee Savings Bank, a collecting check for someone not entitled to it was also considered negligent. BNM requires all banks to follow KYC procedures and verify the identity of anyone opening an account or depositing large checks. Next is application. In this scenario, Ms. Jana from Rupa Bank opened an account for Robert and processed a 20,000 ringgit check made out to Roberto without verifying Robert's identity or expecting the check for alterations. This clearly violates BNM's due diligence guidelines. Just like in rubber industry and Asamaju, this shows negligence on the bank's part. Since there is no evidence that Roberto contributed to the loss, for example by carelessly handling the check, estoppel under Section 73A BA does not apply. In conclusion, Rupa Bank acted negligently and cannot claim protection under Section 85 BA. The bank is fully liable for the 20,000 ringgit loss, and Roberto has the right to recover the amount through a legal action for conversion. That's all from me. Thank you.